Sorry, one of our panelists is getting mic'd back there. So we're a little out of order. But I am Kashmir Hill. I write about privacy and technology at the New York Times. The panelists actually have a lot in common. It's a panel of lawyers. Alvaro and Alex were co-workers for quite a long time. Both worked on legislative issues with the Judiciary Committee in the Senate. Alvaro founded the Georgetown Institute of Technology and Privacy.
That would be Alex.
That's me.
Alex founded it. Alvaro.
Privacy Center.
Alvaro
we try to make it as confusing as possible as our goal. Yes.
So worked there together. And Matt Platkin recently was confirmed as the Attorney General of New Jersey. Started at the beginning of this year. Alvaro fairly recently confirmed as an FTC commissioner. And we're all interested in the topic of the panel, consumer rights, privacy. And so I just want to start off by asking the three of you, what is kind of at the top of your agenda as the most pressing issue right now in this kind of very large sphere of consumer rights and privacy? And I'm going to start with Alvaro.
Sure. It's wonderful to be here with you and with the folks from Aspen Digital. I'll give an answer that may be a little counterintuitive given our shared interest in face recognition technology. I spend a lot of time worrying about and trying to get a handle on the relationship between social media and teenage mental health. I think this is an issue that people from my corner of progressive tech policy, the world I came from and academia, have spent too little time thinking about this. And while there's some hyperbole, we now have 8 years of peer-reviewed social science research arguing that not only through correlation but causation, there's a problematic relationship between prolonged use of social media and clinical anxiety, clinical depression, suicidal ideation, thoughts of self-harm. And the two things that I have, together with my team, zeroed in on as potentially helping us get a handle on this relationship. The first is establishing through statute, ideally through statute, and there's a bill in Congress to do this, a bill just passed in California to do this, to establish a best interest of the child standard that applies to tech companies to force them to use non-public information that they are always the first to learn about, the first to be privy to, and hold their systems up to that standard to make sure they're not harming children and teenagers. And the second is, there was just a discussion in the last panel about the law lagging behind technology, and I think sometimes we give a little too much credit to technology, and I think recent events suggest that maybe the law is a pretty good thing to have in place before technology, but the point I'd like to make is, not only does, yes, the law sometimes lag behind technology, but expertise lags behind both. And expertise does not always follow. And so, speaking of the Federal Trade Commission, for decades we've sought to protect consumers in part through the help of economists. So we have dozens of economists who can measure what we allege to be consumer harm down to the cent, right? Thanks to a number of folks that we know and call colleagues and friends, we have had technologists at the Federal Trade Commission for maybe a decade plus. And so now if there's a tech issue, a thorny, complex issue, I have a bunch of technologists I can ask, what the heck's going on here? I'm just a lawyer, you tell me what's going on here. But we do not yet have psychologists at the Commission, nor do most tech regulators and enforcers in the space. And it should come as no surprise that in an attention economy where the unit of value is the amount of time we spend online staring at the screen, that the harms are going to be psychological in nature and related to mental health. And I'm eager to make sure we have the expertise in place to grapple with that, understand with that, and address it.
So you'll be pushing the FTC to hire more psychologists, have them on staff to work on these issues?
In fact, it's already part of the strategic plan. There's a 5-year strategic plan in place from 2002 to 2022 to 2026, and part of it is to explore bringing on staff psychologists with a particular focus on child psychologists, youth development experts to do that.
And you would like technology companies to be measuring this internally, have some kind of standard they're supposed to meet, that their product is basically healthy for children?
So sorry, did I interrupt?
No.
No. So the I wouldn't call it a secret, it's actually all public. They're already doing that. So in the same way as, the NSA was one of the nation's lead employers of mathematics PhDs, if you go on LinkedIn and you look at public information around who companies are hiring, today they are hiring dozens upon dozens upon dozens, actually no, hundreds of PhD psychologists, both to design their platforms to be as sticky as possible, and also to evaluate and address harm. And so all I want is for enforcers and regulators to have the same skill sets internal to their work as tech companies already are using today, both to keep us online and to assess the harms that come from that activity. So what we need is to catch up.
And then how does that fall under FTC kind of jurisdiction?
Sure. So another thing that I was speaking about with the Attorney General is a lot of people say, oh, well, you have old laws, they don't really apply to this, and that's not true. We, both in New Jersey, all states, and the federal government, we have a law, and the federal government, we've had it since 1938, that prohibits unfair and deceptive trade practices. Doesn't include the word privacy, doesn't include the word cybersecurity, but those words still have meaning today: unfairness, deception. And the test for deception is: did you tell someone obviously simplifying? Did you say you were going to do something and not do it in a way that harmed people, or did you materially omit information about your practices, things that you knew about how your platform functioned, and still let people use the platform despite that? So that's one way this conduct in theory could be reached. And when it comes to unfairness, you have substantial injury. It doesn't just mean people being sad, but critically, that's not what we're talking about. We're talking about clinical anxiety, clinical depression, suicidal ideation. There's not a single person in this room, I think, who would say, oh, that's not a substantial injury. But then you need to prove it's not reasonably avoidable. You need to prove also that it's not outweighed by other harms. And so, yes, we have old laws, but it's not like people in 1938 weren't quite smart. And they purposefully set out laws that would allow us to protect the American people for generations to come.
Fascinating. Okay, Alex, I'm going to move on to you. What is kind of your top issue right now that you're looking at, hoping to do something about?
Sure. So I run an organization focused on consumer rights and democracy in the digital age. So there's a lot on the list. I think one of the issues that I think is worth calling out here is the intersection of privacy and civil rights. And I think for a lot of people, when they come to this issue for the first time, you think of privacy and it's an individual's ability to control what information is shared from them with the outside world. But in reality, in a moment where we can't really control what information is shared about us with the outside world, there's a whole other set of harms, which is what inferences are being made about you and how are the breadcrumbs of information that we leave across the internet in the course of our daily lives being used in a way that can dramatically impact economic opportunity, people's ability to express and explore themselves online. We are seeing, many people of course are familiar with the notion of redlining, right, which is discrimination based on the history of your zip code. Now there are so many more data points than just a zip code that can be used to tailor ads to a particular audience, to evaluate who is eligible for a job. There are an increasing number of vendors and tools that are purporting to use machine learning to come up with the ideal profile of a job candidate, for example, qualifications for a loan, tenant screening algorithms, for example, all of which are comparing individuals to a much broader data set and inferring does this person have the right traits to match what we are selecting for in this instance. And all of that is leading to very real-world harm. I think a lot of times privacy harm can feel abstract. Discriminatory uses of data is not abstract. That is a real-world harm that we need to grapple with. So that's why both my organization, the CDT, and a wide range of civil rights organizations, Alvaro in his former career before joining the commission, are really so focused on making sure that civil rights is a central part of the privacy conversation, including in privacy legislation and also in best practices for companies. And we've seen leadership from the Biden administration on this recently. The White House recently released its blueprint for an AI Bill of Rights, trying to articulate a number of these harms and what companies can be doing to address them. I think it's a critical piece of the conversation.
And so is your focus primarily on the way that companies, the private sector, is using data, or all of the above, government and companies?
All of the above. So we do a lot of work on government surveillance as well, and so that is also hugely important. I know we're going to talk about face recognition later on the panel. But largely in the commercial sector, I think it's hugely important. And we need a combination of solutions, right? Legislation should provide the backstop, make sure that people are equipped with tools to defend themselves and give the enforcers something to use. But also companies really need to be out ahead of the curve on this, and I think some are trying to be. Really, auditing their products for what some of the discriminatory impacts might be, making sure they're doing so on a continual basis, not just at the design phase, but at the implementation phase. And as a general matter, we need to make sure that the public and consumer advocates are aware of these risks so that they can try to step in to protect people as well.
So as an organization, in terms of what CDT is trying to do on the issues that primarily public education and kind of pushing for legislation, or are there other things that you're trying to do?
Yeah, so legislation, talking to the enforcement agencies. One of the important tricks of different enforcement agencies is not only that they can bring actions, but also that they can issue guidance. They can give speeches to audiences, and they tend to listen when the regulators speak. So we try to make sure that they are playing that role as well. There's also a lot to do, this is to Alvaro's earlier point, on equipping the government to even be identifying these cases and knowing to look out for these harms. So one of the things that really matters right now is ensuring that the civil rights-focused agencies, whether that's the Equal Employment Opportunity Commission, the Consumer Financial Protection Bureau, the Department of Justice, their state and local counterparts, know about these harms, have the in-house capacity to actually be looking for these cases and bringing them where they need to, and as I said, issuing that guidance to industry as well.
Okay, and then I'm going to go to you, Matthew. What is the top of your list right now in terms of biggest problem that your office wants to address?
Well, first of all, let me just say, Aspen, thank you for having me. I feel like a trailblazer being a New Jersey Attorney General speaking at the 92nd Street Y in New York City. So this is a really incredible moment. But this is basically everything that's been said. I mean, to be honest with you, I'll give you sort of a general answer and then a specific. Generally, I am, and as a state, we are very concerned about companies putting out terms of services or privacy policies that they then blatantly don't adhere to. And as has been said, we may have old laws, but that is just a deceptive business practice that has not been legal in the state of New Jersey and in most states and under the federal law for a very long time. And so most of our investigations that have produced significant outcomes are, not all, but many of them are based on that theory. And so we see it in all kinds of conduct. Obviously, we see it in the data privacy context, and I'll talk specifically in a second about one example of that. But we also see it in the rise of bias incidents and what companies like Facebook have said they're going to do to moderate the content on their platforms and prevent hate groups from spreading actions in ways that the government cannot because of First Amendment protections. But once they say they're going to do it, they have to do it. We see it in a whole range of contexts. And so in the data privacy context, we've certainly seen it. And actually, we're looking, and this is public, we're looking at Instagram and TikTok for targeting youth and using similar theories that I just talked about. And the impacts you mentioned are very scary. And I'm very proud that it's a bipartisan collection of AGs that are looking at that. That's not an issue that has broken down along partisan lines. So I think generally people are concerned about that. But data privacy, it's the same thing. I mean, we just had a settlement last week, earlier this week rather, a very significant settlement with Google over their data tracking policy. What they were saying to their consumers was just not what they were actually doing.
In terms of location tracking.
Yeah, exactly. And then in a very specific context, in a very real sense, and to your point where things can seem abstract when we're talking about technology and data, and the average resident of my state does not understand what's going on in their phone. That's true pretty much everywhere. But we're seeing it in a real way right now when it comes to reproductive health. And post-Dobbs, there is both a very real fear by providers and people who are taking advantage of legal reproductive health care services in states like New Jersey, that their data is going to be used against them. It's going to be obtained by other investigative agencies, and potentially they could be found to have liability. Now, under New Jersey law, they're protected. But I still have a lot of concerns about what tech companies, big and small, are doing with that data. Everything from the apps on the stores, as well as what Google and Apple are doing as it relates to their own data tracking and those who make their apps available through their platforms. And so those are very much unanswered questions right now. And we were talking about this backstage. We're doing a lot. We have a lot of tools. But this is an area that I've seen, because we, on top of everything else, we license the medical providers in the state. So I know the fears that they've had because I've spoken to them. And it's very much came to a head. Obviously, no one was necessarily, I mean, Dobbs was, I guess, to some degree foreseeable, but no one was really expecting that decision, a year or two ago. And they've had to adjust very quickly in real time.
And the concern is not as much the reproductive health privacy of New Jersey residents, but people who would be coming from out of state to get abortions in New Jersey.
Look, I think it could be both. I think anyone who's providing these services or taking advantage of them has concerns about where their data is being stored, if they do come across state lines, who could potentially get access to it. Remember, a state like New Jersey, we're a state that a lot of people pass through. A lot of people, it's very easy to travel to our state. We have some of the strongest reproductive health care protections in the country, which I'm very proud of. And we have a strike force that brought together all of our civil and criminal authorities to ensure that those laws are protected. And the governor signed laws that significantly restricted what data could ever possibly be shared, even to another state seeking that information, whether it be from healthcare providers or from a state or governmental agency. But there's still a lot of gaps in terms of what the companies themselves have done, and even what they're saying about what they have done, both for us as regulators and enforcement agencies, but also for the providers and the public. We're talking about some of the most sensitive and difficult moments in people's lives. And now you add a layer of uncertainty onto that as to if I'm taking advantage of a legal service in a state that I know I'm allowed to do it, could somebody through a phone that's in my pocket or from a period tracking app or any other, or data that my doctor is going to get, is that going to go somewhere that I'm not going to have control over? These are things that they might not even tell their parents or their spouses or their partners about, but they're putting that trust in companies that frankly don't have a great track record when it comes to this issue. And so it's a very real sense, and I think it sort of grounds when we're talking about data privacy, and this is true, as you said, whether it's algorithmic bias or any of the issues we're talking about. They're real issues in people's lives, and that's where, as an attorney general and my counterparts across the state and in the federal government, we have an obligation to use our laws to protect our residents. Just because it's new technology doesn't mean certain practices that were illegal if you did it by phone or by letter or by advertisement on a billboard is now legal if you do it on a social media platform or an app.
I mean, theoretically, in terms of the way that the AG's office would get involved in a case like that, I mean, would it be there's some kind of information request happens over state lines from another law enforcement agency? Would the AG's office get involved in some way at that level, or is it more just regulating what providers in New Jersey, what information they would make available?
Yeah, I mean, we could get involved in a number of ways, and sometimes we might not know. I mean, if one of the reasons why the laws were signed is because if, let's say, another state were to subpoena records, it wouldn't necessarily get on our radar if it was to a third party. But we get involved in a lot of ways. I mean, we're in the business of suing people a lot of the time, so we have investigative powers, and we bring lawsuits as it relates to data breaches, and that's not just because it's what we want to do. I mean, we prefer that it didn't happen, but we are tasked, and I am tasked in New Jersey with enforcing our laws. And we've used our tools in that sense, but we also, whether it be through the regulatory process or by promoting good policies or just good hygiene from the industry. I mean, I would much rather, it's A, much less resources, and B, much more productive when we're working together to change conduct in a way that benefits the residents of our state. I'd much rather do that than have to file a litigation and get 40 other states to go along with us. That's much harder, and frankly, I think not the best use of resources and not the best outcomes for the companies either. And so we have a lot of interaction with industry, and they've been, at times very cooperative, and then other times they haven't been, and then it's resulted in us having to take enforcement actions.
I think within the privacy sphere, we've talked for a long time about how there's so much medical data that is unprotected because, a lot of people think, oh, HIPAA protects everything medical related, not realizing that it applies very specifically to medical providers, and that there's now so much reproductive health data, medical data that is kind of flowing through third parties that are not medical providers, and so it's not provided by HIPAA. And Dobbs has really brought that kind of long-going conversation into very sharp focus. And so, Alex, I am curious. I know this is something the organization has thought about a lot, but at this moment, how are you thinking about that, the protection of medical data that's increasingly flowing outside of the kind of medical establishment that's regulated by HIPAA?
Yeah, it's a great point. And I think one thing, again, there needs to be consumer education because people think that stuff is protected, that it is not. As we stand here today, there is not a single federal law that protects consumer privacy and the types of commercial sources of information that we're talking about. Instead, we have to rely on a patchwork of laws and the consumer protection provisions, either that states or the Federal Trade Commission can enforce. So we need a much more sophisticated conversation around privacy legislation and making sure that there are baseline expectations for how data can be protected. The other piece of this, of course, is asking the companies. I mean, to the point that you were making, I think this really has been a wake-up call for many consumers about just how vulnerable their information is. That your phone probably knows more about you than any single person in your family at any given time, and that information can be highly revealing. I think one of the elements of the Dobbs decision that has made this such a sharp moment is realizing that people have to worry not only about law enforcement access to that data, but also the potential of lawsuits and pursuit from bounty hunters in certain states as well. And so, to be honest, whether one actually expects to be in the market for reproductive healthcare services or not, I think many people are realizing, hey, that there's a lot going on here. So one of the other areas that we're focusing on is really spending time with the companies about how they can better improve their data practices in that regard. And the answer here, if they do not want to be handing over or faced with the uncomfortable scenario of law enforcement subpoenaing them for their customers' most sensitive information, is minimization. Don't have that data in the first place. So there's a lot more companies can be doing to reduce the amount of data that they have, to reduce how long they hold it for, of course to think about who they're sharing it with, where they're selling it to. And underpinning all of this, of course, is the market of data brokers, kind of this additional realm in the ecosystem that are there buying pockets of information from all of these different providers and aggregating them to create profiles for people that law enforcement can then come and access without having to get a warrant or follow, traditional criminal procedure. So the companies do have a really important role to play here. I think this is a wake-up call moment where their customers are looking to them with strong expectations that they're going to follow through.
I think after...
Can I jump in with one very quick thing? I wanted to flag a lawsuit that the Federal Trade Commission filed a month or two ago. It was a bipartisan vote against a company called Kochava. And what we allege is that they broke the law by selling detailed information about their users, geolocation information, and giving it away online to prospective customers. And in doing so, gave away information about people's trips to reproductive service centers, addiction treatment centers, churches. And so we are trying to, as many other law enforcers are across the country, we are using the tools at our disposal to try to address this, but absolutely more legislation would be helpful.
And were they giving out specific identified information, or this was kind of
so there's some nuance
aggregated?
To it. My understanding, and I don't want to get it wrong, but the complaint, my recollection of what the complaint alleges is there was pseudonymous identifiers, but they were persistent identifiers. And so, if I don't call you Cash, but I call you, some other name, but I always call you that name,
right.
That functions as an identifier, like a nickname, right? If I call you K, right? That might serve the same function. And so that is, I think that was part of the kind of fact pattern in that case.
And after the Dobbs leak, really, there was a call for women to delete their period tracking apps. There was a lot of concern about how this data might be used. Have you seen that data being used yet? Kind of what's the most concerning data use you've seen happen so far since the ruling, since kind of state laws have started changing?
So I will say I was actually very worried by the period tracking app news stories. They served an important function for raising consumer awareness, right? You should always be smart about the apps you're using, what their terms of services are, what promises they're making to you about how they'll use that data or not use it, so that enforcers can come after them if they don't live up to those promises. But one of the things that made me worry is that people, if that was presented as the fix, delete that period tracking app and you are good to go, wow, is that some misinformation for what the actual threat model looks like, right? If you think about, so there have already been cases brought prosecuting pregnant people for their pregnancy outcomes. And this includes before Dobbs, when pregnant women have been prosecuted for taking drugs during their pregnancy that resulted in the miscarriage of the fetus, for example. Or for people taking self-medication abortion outside of the statutory limits that were permitted in states, even under Roe. And in those prosecutions, the information that's being used is internet search history, the private conversations that people are having with their best friends via text message in their time of need. And so it is these mainstream uses, right? Ones that you can't delete that function on your phone. That's the whole reason you have it, right? This is a story about a lot more in terms of the vulnerability, and it's a lot more than individual users can control. So yes, users need to be smart. There are great resources online about how to do that. But also, we need these minimum protections, and we need the companies to step up to protect their customers.
For a long time, talking about privacy issues, at kind of the end of every story I wrote, somebody would say, we need more laws to protect privacy. We need a federal privacy law, and it has not happened for about the decade or so I've been covering this. Though there have been interesting state laws, some that were passed very early on. I think that probably the most important one is the Biometric Information Privacy Act in Illinois that was passed in 2008, before most tech companies were using any kind of biometric facial recognition. There is yet again a privacy law kind of at the federal level, hovering, might or might not move forward. Alex, I was wondering if you can fill us in on where it is now, if you think it's likely to move forward or not.
Yeah, so you gave a great setup. People have wanted this for a very long time. There are not many issues in the world today, in the United States, where you have Democrats calling for it, Republicans calling for it, consumers calling for it, businesses calling for it because they know that they want a baseline standard for user trust and some guidance about what the rules of the road are going to be. So the conditions are ripe. There is a piece of legislation, the one that you're referencing here is the American Data Privacy Protection Act, sometimes known as the ADPPA. And it recently passed this summer out of the House Energy and Commerce Committee by a bipartisan vote of 53-2. There are, again, not many issues that are getting that type of bipartisan buy-in. So one of the things I think is most exciting about that bill is that it really does move the ball forward substantially in how we think about privacy. The traditional framework for a long time was one focused on notice and consent. So if the company told you they were going to do something with their data, even if it is on page 57 of the terms of service, which even I, a privacy lawyer, do not read, they could get away with it, right? Because they've told you and you've consented by using their service.
Right.
The ADPPA takes the really important, just evolutionary step of saying that doesn't work. Users do not have choice in that scenario. That is not the way to regulate. Instead, we need baseline protections, rules of the road. It also has civil rights language in there to the point that I mentioned earlier. It has a private right of action for users to be able to enforce their rights. So there's really good stuff in there. The question is how we get it across the finish line in what is a difficult political climate right now. The main issue for this bill that is holding it up right now is that part of the grand bargain is that it does preempt some state laws. It doesn't preempt BIPA. But it does.
How did BIPA manage to carve its way out of that?
It's been the law for long enough now that people understand it. They recognize that protection. Companies are complying with it. So, but it does have a preemptive effect on California's recently passed privacy law, which is a challenge because obviously California was an innovator in that space. There's a whole weedy conversation to be had around that. I think for many of us consumer advocates, we think that the protections of the federal bill are stronger than what's in the California law. And also, number one, it allows the California enforcers to keep enforcing and kind of keeping their function. And also, we need to protect people not just in California, but around the whole country. But we will see what happens with it.
Sitting in the New Jersey Attorney General's office, how much does this matter, the kind of the federal privacy conversation? How would it impact you if that law passed? Do you want something like that, or do you feel like you have the tools you need right now at your level to enforce these rights?
It matters a lot. Chairman Pallone, Frank Pallone, is New Jersey congressman, chairs the committee at least for a couple more months that the bill passed through, and I've spoken to him about it, and I know how hard he's worked to get it through. And those numbers you don't hear very often in terms of bipartisan support. There's certainly I think a healthy debate amongst AGs in various states about the preemption question, and that I assume we'll shake it out. But the federal law is a very significant step forward, and giving us the tools to enforce is a step forward. From my perspective, and this is true for every time we pass a law, I say this, but particularly in this space where there's such a dearth of experienced investigators and lawyers in public sector doing this work, it's really important that some of you folks and those come into government and work on these issues. Because I'll tell you from us, if we don't have the tools to enforce the law, then it's just a nice press release. And so any law we're tasked with enforcing, and it's true from the federal agencies or in state attorney general, which play such a critical role, we are aggressively building out our data privacy team. We already have one of the best in the country, I would argue, and we are expanding that rapidly. And I also co-chair a new center set up by the National Association of Attorneys General on cyber and technology. And one of the pushes that I feel very strongly is, we need to be providing state AGs resources, technologist resources that are hard to get into state government, so that as we're building these cases, A, we're not pursuing cases that really shouldn't be pursued and wasting government resources and wasting companies' time when we can just work out an issue, but B, that when we need to pursue an enforcement action and when we have those tools, that we have an obligation to our residents to be able to put them to work.
What about sitting in the FTC? And I know you probably have feelings about privacy being a bipartisan issue and yet not being able to get a law passed on it at the federal level. But with or without a privacy law at the federal level, how does it impact what the FTC is able to do?
So, like I was saying earlier, we're doing absolutely everything possible that we can using the authority we have, and it is a broad authority. We also have a rulemaking authority that Congress gave us in a couple decades ago that we are exploring whether we can use and should use to address some of the issues that have been discussed during this panel. But frankly, for the commission, what would be most helpful is resources. And the interesting thing about the Federal Trade Commission, it's the oldest consumer protection agency in the country. I would argue it's the preeminent one. And so when Congress passes a law, they say, oh, FTC, you enforce it. And they'll pass a law about, great laws, right? Laws about, ticket resales, laws about kids' privacy. But they'll just add on a thing that says FTC shall enforce it. And yet our staffing is lower than it was in the 1980s. And so, and in the 1970s, absolutely. That for me is the key issue. The law that Congress is considering is terrific. It's got everything we've discussed: civil rights, biometrics, kids' privacy, kids' information. They have strong provisions there, and we'll use them. But for me, my main concern is making sure that if Congress tells us to do something, they give us the resources to do it.
I am curious, you bring up biometrics. I'm obsessed with facial recognition technology because I wrote the story at the New York Times about Clearview AI, which had scraped the internet of billions of faces, created a facial recognition app that could identify just about anyone, and was selling it to law enforcement. And I wanted to ask you about it, Matthew, because when that story came out, the then Attorney General of New Jersey kind of put a moratorium on the use of Clearview AI and launched some kind of, fact-finding investigation into how facial recognition was being used in New Jersey. And I just wanted an update on what's going on with that.
So Clearview is still not operational. The moratorium is still in effect in New Jersey, and it's been almost 3 years. Earlier this year, we launched actually a public process for soliciting input on facial recognition technology from stakeholders, and that process is still ongoing. So nothing new publicly to report, but this goes to sort of, I think, a broader issue. I mean, law enforcement, a lot of these issues come to the head with respect to law enforcement. And, as the chief law enforcement officer, obviously there are times when new investigative tools are very helpful. But there's also the competing concern about individuals' privacy, the same way they had privacy expectations in their home, and there's bodies of case law about all of this that is still, there's still a work in progress to catch up to some of this information. But as it relates to facial recognition technology specifically, Clearview is still not allowed in New Jersey, and we are going through a pretty robust process to evaluate what the right safeguards are.
We're going to do a lightning session here because we're running out of time, but I wanted to end our panel with kind of something brighter, like a reason for hope. And I'm just wondering if, privacy, digital rights have been an issue since the internet kind of became mainstream, used by society. What have you seen in the last decade or so that gives you hope about our giving people more rights on the internet, protecting people's privacy? What are the bright spots, if you could name one quickly? And I'll start down here and then come this way.
I think its public attitudes have changed dramatically just over the last decade in terms of what people's expectations are for how their information will